belongs with profound respect to its humility. We remain Major J. O. Moore, Captain N.P. Zitman, and Captain N.E. Oku for the prosecution.
My novel has been placed, Chuku and Abbas. For the defense, and our beloved friend will soon be joining us.
Okay, without wasting of time, go straight to the award of punishment. Award of punishment by this General Court Martial in the case of Armed Forces of Nigeria versus M5159 Ex-Seaman Abbas Haruna. The accused rating was charged on 3 count charges of disobedience to particular orders, resistance to arrest, an offense in relation to public and service property, contrary to Section 56 of Section 1, Section 86 of Section 1, and Section 66 of Section C, respectively, of the Armed Forces Act of 820 Law of the Federation of Nigeria 2004. The accused rating was earlier arraigned before the court and he pleaded not guilty to the 3 count charges. However, the defense counsel made an application in line with the rules of procedure Royal Navy BR 11, which is in consonance with the rule of procedure Army 1972. To this court, to enable the accused rating change his plea. The application was not opposed by the prosecution counsel on the ground that it is the right of the accused rating to change his plea anytime during the proceeding before judgment. The accused rating pleaded guilty to the 3 count charges, and his plea of guilty were duly accepted by this court. The prosecution thereafter availed this court with the summary and abstract of evidence. The prosecution further tendered 7 documents as exhibits in this case. The defense, however, did not object to all of the documents, and they were admitted in evidence and marked as exhibits A to G. The accused rating himself made a plea of mitigation of punishment. He personally appealed to this court to temper justice with mercy. Thereafter, the defense counsel submitted that the accused rating may have committed the offense as a result of his inexperience in service, looking at the number of years he spent in service, which was nearly 4 years at the time of the commission of the offense. He further pleaded with the court to consider the adverse effect of the punishment to be awarded to the accused rating by this court. However, in all of the submissions of the defense counsel in his plea of mitigation, this court consistently observed that the countenance of the accused rating is more of unremorseful and unapologetic. The accused rating attitude of disobedience to lawful authority, which was indeed similar to one of the count charges which he faced in this criminal trial, continued to manifest even while the proceeding was ongoing. It is therefore out of the principle of justice and fair trial that this court accepted the accused rating change of plea. However, this court will not be deterred from ensuring that justice is meted out in this case. One can only action of the accused waiting when he disobeyed the order of a senior officer and yet blatantly resisted arrest and still went as far as expending 16 rounds of 7.62mm special. What agitates the mind of this court is that the action of the accused waiting could have resulted in the death of any of his colleagues, which could have occurred from his sporadic shooting. The action of the accused waiting is no doubt an act of gross indiscipline, capable of taking the lives of his colleagues. It is now evident that the accused waiting, by his action, can never be trusted with rifle in the armed forces of Nigeria. And if so, it therefore means that as a rating in the Nigerian Navy, who cannot be entrusted with rifle, there is no doubt that he will not be useful to the Nigerian Navy and indeed the armed forces of Nigeria anymore, since soldiers rating and aircraft mates are trained for the purpose of weapon handling and judicial applications when called upon for the protection of the sovereignty of the Federal Republic of Nigeria. Consequently, this General Court Martial find the accused waiting guilty on the 3-count charges as he earlier pleaded. This court thereby sentenced M5759 Seaman Abbas Haruna as follows. Count 1 on disobedience to particular orders, reduction in rank from seaman to ordinary seaman. Count 2 on resistance to arrest, dismissal with enormity from the armed forces. Count 3 on offense in relation to public and service property, dismissal with enormity from the armed forces. However, counts 2 and 3 shall run concurrently. This judgment is, however, subject to confirmation by the appropriate superior authority. This judgment is dated this 7th February 2023.
We shall not bet time of industry and your magnanimity, even though in your sentence. We say we're very grateful, and may the Almighty continue to guide you as you continue your other deliberations. That's our appreciation.
The prosecution, any other thing?
My Lord, we very much appreciate the court for the industry and the well-balanced judgment and sentence. It will go a long way to send a message, strong one, to any other would-be offender. My Lord, on this note, we want to most respectfully announce that that's the end, the only case, at the end of the cases we brought before this General Court Martial for today and for the time being, and maybe subject to the overriding decision of the convening authority, the court may adjourn sine die. Thank you, my Lord.